Welcome to Law Review Hub. We are dedicated to exploring legal concepts, case law, and the fundamental principles of law. In this series, we'll be covering contract law in depth, reviewing key cases, and breaking down complex legal topics into easy-to-understand explanations. In today's video, we are starting with the basics. What is a contract? Whether you're making a simple purchase, signing an employment agreement, or negotiating a business deal, contracts are everywhere. Understanding contract law helps protect your rights and ensures that agreements are fair and enforceable. What is a contract? Well, at its core, a contract is a legally enforceable agreement between two or more parties. Under U.S. common law, a contract is defined as a promise or set of promises that the law recognizes as binding, providing a remedy if breached. This means that if one party fails to fulfill their promise, the other party has legal grounds to seek enforcement or compensation. To better understand contracts, consider this example. Imagine Alice agrees to sell her laptop to Bob for $500. Bob accepts, and they both agree on a payment and delivery method. This is a legally binding contract. If Bob fails to pay or Alice refuses to hand over the laptop, the other party can take legal action. However, not every agreement is a contract. If someone casually says, "I'll sell you my bike for $50 sometime next month," but doesn't follow through, courts may not consider this a binding contract because the terms were too vague or lacked a clear commitment. For a contract to exist, the parties involved must intend to enter a legally binding agreement. This follows the objective theory of contracts, meaning courts will look at how a reasonable person would interpret the actions and words of the parties, rather than their hidden thoughts. If a statement was clearly meant as a joke or was made in a casual, social setting, it's not a contract. However, if two businesses exchange promises in a professional setting, the law assumes they intended to be legally bound. For example, if someone jokingly says, "I'll sell you my house for $1," and the other person accepts, no reasonable court would enforce that as a contract. But if a company formally agrees to supply materials to a construction firm, the expectation of a contract is clear. Contracts in the U.S. are primarily governed by common law, which has developed over centuries through court decisions. However, not all contracts are treated the same. Contracts for the sale of goods, such as cars, electronics, or clothing, are governed by Article 2 of the Uniform Commercial Code (UCC). The UCC applies only to the sale of tangible, movable goods and does not cover real estate, services like legal advice or tutoring, intangible assets like stocks or patents. If a contract involves both goods and services, such as installing a water heater, courts determine which part is dominant. If the main focus is selling a product, UCC rules apply. If the service is more significant, common law applies. The UCC also distinguishes between merchants and non-merchants. A merchant is someone who regularly deals in goods of a particular kind or has specialized knowledge about them. For example, a car dealership selling a vehicle is a merchant, but a private individual selling their used car is not. This distinction matters because merchants are held to higher standards of fair dealing and good faith in business transactions. Every contract, whether under common law or the UCC, includes an expectation of good faith and fair dealing. This means that each party must act honestly and fairly when performing the contract. If one party deliberately exploits loopholes to avoid their responsibilities, they may be in breach of contract. Even if a contract technically allows an action, it cannot be used to unfairly deprive someone of what they are owed. For example, if a supplier agrees to provide raw materials at a set price but intentionally delays delivery to force the buyer into a higher payment, courts may rule that they acted in bad faith. For an agreement to be legally binding, it must include these four essential elements. Offer: one party must make a clear and definite proposal. Acceptance: the other party must agree unconditionally to the offer's terms. Consideration: each party must exchange something of value, money, goods, or services. Legal intent: the agreement must be for a legal purpose. Courts won't enforce illegal contracts. For example, if Alice offers to sell her laptop to Bob for $500 and Bob accepts, a contract is formed. However, if Bob makes a counteroffer like offering for $150, the original offer is rejected, and negotiations continue. Do contracts have to be in writing? A common misconception is that all contracts must be in writing. In reality, many oral contracts are legally binding. However, under the statute of frauds, Some contracts must be in writing to be enforceable, including contracts for the sale of land. Agreements lasting over 1 year, contracts involving large financial transactions. When disputes arise, courts rely on evidence, including written documents, witness testimony, and the actions of the parties. Contracts shape both personal and professional transactions. Whether you're signing a business deal, buying a product, or agreeing to services, understanding contract law helps protect your rights and ensures fair dealings. Thank you for watching. If you enjoyed this video and want to learn more about law and legal cases, make sure to subscribe to Law Review Hub and activate the notification bell so you never miss an update. See you in the next video.